When we talk about the difference between an employee and a contractor, we're really talking about the difference between having a safety net and being left on your own. Most people don't realize just how big that gap is until something goes wrong. Let's start with employees. If you're classified as an employee, you have legal rights that are built into U.S. labor law. For example, you're entitled to at least the federal minimum wage and in many states, even higher. You also qualify for overtime pay if you work more than 40 hours in a week, unless you fall under special exemptions. Beyond wages, employees often have access to important protections like unemployment benefits if they lose their job, and workers' compensation if they get injured while working. On top of that, many full-time employees also receive health insurance, retirement plans, or paid leave. In short, being an employee means the law recognizes that your livelihood depends on your job, and therefore you deserve certain protections. Now compare that to being an independent contractor. Contractors are treated as self-employed. That means the company you work for doesn't have to pay you overtime, doesn't have to provide benefits, and doesn't contribute to your unemployment or workers' compensation. You're also responsible for paying the full share of Social Security and Medicare taxes, something employees usually split with their employer. In other words, contractors carry all the risk themselves. But here's where it gets tricky. Many gig workers are told they're contractors, even though the way they actually work looks a lot like being an employee. Think about it, if you're logging into an app that decides when, where, and how you do the work, are you really independent? Or are you working under company rules without the benefits that normally come with being an employee? That's the heart of the debate. For workers, this distinction isn't just paperwork, it's about fairness. Being misclassified as a contractor can mean losing out on thousands of dollars in pay, overtime, and benefits every single year. And for families who rely on that income, the difference can be life-changing. So the first question you should always ask is, am I really an employee, or am I truly independent? Because the answer to that question determines one of the biggest misconceptions in the workplace, especially in the gig economy, is that whatever your company calls you, that's what you are. If the company says you're an independent contractor, many workers assume that's the end of the story. But here's the truth, the label doesn't decide your legal status, the law does. Think about it this way. Imagine you walk into a store, and the sign outside says organic. Does that automatically mean everything inside is truly organic? Of course not. Labels can be misleading. The same thing happens with job classifications. Companies often use the contractor label because it saves them money. If they classify you as a contractor, they don't have to pay overtime, they don't have to provide health insurance, and they don't have to pay into unemployment or workers' compensation funds. For them, it's cheaper. But for you, it could mean losing out on thousands of dollars in protections and benefits. The government knows this, which is why agencies like the Department of Labor, the IRS, and even state labor boards look beyond labels. They use different tests to see what your work really looks like. Do you control your own schedule? Do you invest in your own tools and equipment? Can you freely take on other clients? Or does the company control the core details of your work, like when, where, and how it gets done? If the company is in the driver's seat, you might actually be an employee misclassified as a contractor. And here's the catch, misclassification isn't a small issue. Studies estimate that millions of U.S. workers are misclassified every year. These are people who should legally be getting minimum wage, overtime, or benefits, but instead are told, sorry, you're a contractor. The difference between the label and the reality can mean losing out on healthcare coverage, job security, or retirement contributions. So what's the takeaway? Don't just accept the title you're given. If you're called a contractor but you feel like the company controls almost every part of your job, you may not be truly independent. And that means you could have rights you didn't even know about. In the end, the label is just a word. What matters is the actual working relationship. Because in the eyes of the law, actions speak louder than labels. When it comes to figuring out whether you're an employee or an independent contractor, one of the most important factors is something called the control test. And here's the simple idea: the more control a company has over how you do your work, the more likely you're actually an employee, not a contractor. Let's break that down. Imagine two very different scenarios. In the first, you're hired as a true contractor. Let's say you're a plumber. The client tells you, "The sink is leaking, can you fix it?" You decide what tools to use, what time of day to come, how long you'll take, and the method you'll use to fix the leak. The client only cares about the final result, a sink that works. That's independence. That's contractor status. Now compare that to the second scenario. You drive for a delivery app. The company tells you when you can log in, what areas you can serve, which customers you must deliver to, and how fast you need to complete the delivery. If you decline too many orders, the app may penalize you. That's not freedom, that's control. And legally, that kind of control starts to look a lot more like an employee relationship. The control test is used by courts, the IRS, and the Department of Labor to dig into the real working relationship. They look at questions like, who decides your work hours? Do you follow the company's training, policies, or dress code? Are you supervised or evaluated like a regular staff member? If the answer is yes, those are signs you're functioning as an employee. Why does this matter? Because companies love to have it both ways. They want to control the details of how you work, which benefits them, but still call you a contractor so they don't have to provide benefits, overtime, or job protections. That's why so many gig workers feel stuck. They're treated like employees when it comes to rules and oversight, but like contractors when it comes to pay and benefits. The control test exposes that imbalance. It asks, are you truly independent, or are you under the company's thumb? Because at the end of the day, if the company is calling the shots, the law may say you're not a contractor at all, you're an employee who deserves real protections. When we talk about the difference between an employee and an independent contractor, most people think it's just about job titles. But in reality, it's about two completely different worlds of rights, protections, and responsibilities. And understanding this difference could literally change your paycheck and your future. Let's start with employees. If you're officially classified as an employee, the law gives you a safety net. You're entitled to minimum wage and, in most cases, overtime pay if you work more than 40 hours a week. You may also qualify for unemployment benefits if you lose your job, and workers' compensation if you get hurt while working. Many employers also offer extras like health insurance, retirement plans, or paid sick leave. All of this creates stability because the law recognizes that employees rely on their jobs to survive. Now flip the coin. If you're labeled as an independent contractor, the situation is very different. Contractors are treated like they run their own mini business. That means no guaranteed minimum wage, no overtime, no unemployment checks if you lose work, and no automatic health or retirement benefits. On top of that, you're responsible for your own taxes, including paying the full share of Social Security and Medicare, which employees usually split with their employer. Suddenly, the burden shifts from the company to you. Here's where the problem comes in. Many gig workers and freelancers are told they're contractors, but their day-to-day life looks a lot more like that of an employee. If your company is setting your schedule, controlling how you do the work, and relying on you as a core part of its business, are you truly independent? Or are you being classified that way just so the company doesn't have to give you the protections employees get? The difference is not small. Being misclassified as a contractor can mean losing out on thousands of dollars every year. It can mean no safety net if you're injured or laid off. And it can mean you're carrying all the risk while the company saves all the money. So when you hear the terms employee and contractor, don't just think about titles. Think about rights. Because this single distinction decides whether the law is on your side or whether you're on your own. One of the clearest signs that separates an employee from an independent contractor is who controls the tools, resources, and independence in the job. And this might sound simple, but it tells us a lot about the true nature of your work. Think about it this way: an independent contractor is like a business owner. They bring their own tools, their own equipment, and their own methods to get the job done. For example, if you hire a professional photographer, they show up with their camera, their lighting setup, their editing software. You don't hand them a camera and tell them how to take the pictures, you just expect great photos at the end. That's true independence. Now compare that to employees. Employees usually depend on their employer for the tools they need. A nurse uses hospital equipment. A cashier uses the store's register. An office worker logs into the company's computer system. And along with those tools come rules like company policies, training sessions, or specific ways to handle tasks. That's what makes it employment. The company provides not only the tools but also the framework for how you work. Here's where gig work gets messy. Many delivery drivers, for example, use their own cars and phones, which might make it seem like they're independent. But look closer: the app tells them what deliveries to take, tracks their movements, and even sets rules for customer interaction. So while the driver owns the car, the company controls almost everything else. That's a gray area, and it's why so many legal battles are happening in the gig economy. Independence is another huge factor. A true contractor can take on multiple clients at once. They decide their schedule, set their rates, and market their services. They have the freedom to say no without risking their livelihood. Employees, on the other hand, are usually tied to one employer. Their schedules are fixed, their pay is predetermined, and their flexibility is limited. So ask yourself, who really has the power in your work? Are you free to run things your way, with your own tools and your own choices? Or are you operating inside a system built and controlled by your employer? Because that difference doesn't just define your title, it defines your rights. At the end of the day, tools and independence aren't small details. They're the evidence that reveals whether you're truly a contractor or whether you're actually an employee who deserves full protections under the law. Another powerful way to figure out whether someone is truly a contractor or actually an employee is by asking this simple question: is the work you're doing central to the company's core business? If the answer is yes, chances are you should legally be treated as an employee. Let's break it down with an example. Imagine a bakery. The bakery's main business is baking and selling bread and pastries. The people who mix the dough, bake the bread, and serve customers are essential to the bakery's operations. Without them, the bakery cannot exist. That's core business work. Now, if the bakery hires someone to fix the plumbing once in a while, that plumber is clearly not part of the core business. The plumber is a true contractor. They perform a specialized service that supports the business, but they are not central to it. Now, let's take this idea to the gig economy. Think about companies like Uber or DoorDash. Their entire business depends on drivers delivering rides or meals. Without drivers, there is no Uber. Without delivery workers, there is no DoorDash. That means the drivers are doing the very heart of the company's business. And yet, those companies often label drivers as independent contractors. Does that make sense? Not really, because the drivers are central to the service itself. Courts and lawmakers have been paying close attention to this issue. In fact, some states, like California, have adopted what's called the ABC test. Under this test, if the work you're doing is part of the company's usual course of business, then you cannot be classified as a contractor, you must be considered an employee. That rule was designed specifically to protect gig workers who are at the center of billion-dollar businesses but don't get employee rights. Why does this matter? Because being misclassified means losing out on overtime, benefits, and legal protections, even though you're performing the company's most essential work. It creates a situation where companies profit while workers carry all the risk. So the real question you should ask yourself is, am I doing work that the company cannot survive without? If the answer is yes, the law may see you as more than a contractor. You may actually be an employee and entitled to the protections that come with it. Let's talk about what really happens when workers are misclassified as independent contractors instead of employees. On the surface, it might just sound like a label, but the truth is, this single misclassification can cost workers thousands of dollars every single year, and leave them without a safety net when they need it most. Here's the reality. When you're misclassified, you miss out on the most basic protections that employees get automatically. For example, you don't receive minimum wage guarantees. That means if your hours get long and your pay dips below what's fair, you have no legal ground to demand the difference. You also lose access to overtime pay, so even if you work 50 or 60 hours a week, you won't see the time and a half that employees are entitled to. It doesn't stop there. Misclassified workers can't collect unemployment benefits if they're laid off. They don't get workers' compensation if they're injured on the job. Imagine getting hurt while making deliveries or doing construction work and suddenly realizing you're completely on your own for medical bills. That's the harsh reality for many gig workers. Then there are the hidden costs. Employees and employers usually split Social Security and Medicare taxes. But if you're labeled a contractor, you pay the entire amount yourself through what's called the self-employment tax. That means a bigger chunk of your paycheck disappears, leaving you with less to take home. On top of all this, benefits like health insurance, retirement contributions, or paid sick leave are rarely offered to contractors. So workers who are already stretched thin end up covering all those costs themselves. It creates a cycle where people work harder but still fall behind simply because they're denied the protections that should legally be theirs. And let's not forget the bigger picture. Misclassification doesn't just hurt individual workers. It also creates unfair competition. Companies that cheat by calling employees contractors save money, while businesses that follow the law struggle to keep up. That's why lawmakers and regulators are cracking down, because this isn't just about titles, it's about fairness in the workplace. So the consequences of misclassification aren't small. They're life-changing. Workers lose wages, benefits, and protections, while companies pocket the savings. That's why it's so important to ask, am I really a contractor, or am I being misclassified? Because knowing the answer could mean reclaiming the rights you didn't even know you had. When it comes to figuring out whether you're an employee or a contractor, one of the most important things to understand is how state and federal laws come into play. Because here's the truth, the rules aren't always the same everywhere, and where you live can completely change your rights at work. At the federal level, agencies like the Department of Labor, DOL, and the Internal Revenue Service, IRS, both have tests to determine your status. The DOL looks at how economically dependent you are on the company. In other words, do you rely on this one employer for your main source of income? The IRS, on the other hand, looks at control, who decides how the work gets done, who supplies the tools, and whether the worker has true independence. If the company has too much control, or if you depend on them like an employee, then federal law may say you're misclassified. But then come the states, and this is where things get even more interesting. Some states follow stricter standards to protect workers. California, for example, passed AB 5, a law that uses what's called the ABC test. Under this test, a worker can only be classified as a contractor if three things are true: A, they're free from the company's control; B, they're doing work that's outside the usual course of the company's business; and C, they operate their own independent trade or business. If a company fails any part of that test, the worker must be treated as an employee. That's a game changer for gig workers. Other states, like Massachusetts and New Jersey, also lean on versions of the ABC test. Meanwhile, states without strict laws still rely heavily on federal guidelines, which can sometimes leave gig workers with fewer protections. That means two people doing the exact same job, like driving for a rideshare company, might have completely different rights depending on which state they live in. And here's the important part: these laws are not set in stone. Across the country, lawmakers and courts are debating how to handle gig work and misclassification. New rules are being proposed, lawsuits are being filed, and worker protections are constantly evolving. So what's the takeaway? Don't assume the rules are the same everywhere. Understanding both federal protections and your state's laws could mean the difference between being left out in the cold or gaining access to wages, benefits, and rights you deserve. So, at the end of the day, the difference between being an employee and being a so-called independent contractor isn't just about titles or paperwork. It's about your rights, your protections, and your future. Too often, companies use misclassification as a tool to cut costs, but the cost is carried by the worker. If you're in a gig job or you've been told you're a contractor, ask yourself, am I truly independent, or am I doing the core work that keeps this company alive? Am I free to run my own business, or am I tied down by their rules? Because the law is clear, if you're misclassified, you may be entitled to protections and benefits that you've been denied. This conversation isn't just about legal definitions, it's about fairness, dignity, and the future of work in America. Laws are changing, states are stepping up, and workers are starting to fight back. And the more you know, the stronger your position becomes. So don't just accept the label you've been given. Understand your rights. Ask questions. Push back if something doesn't feel right. Because knowledge is power, and when it comes to your work, that power belongs in your hands.